It's filed. It's filed.
I have not received any copy.
In that case, if I can pre-my note, if it can come on Tuesday, my note, because Monday I'm not in sure. I'm not in sure.
On pre-made parties, this is matter on Tuesday. Tuesday that is 16.
Obliged, madam.
Lordship, I beg to mention item number 3, Lordship. I'm praying for 2 weeks' time, Lordship, here.
On pre-made petitioner, this is matter up to 2 weeks.
Obliged, Lordship.
Your Lordship, I beg to mention item number 1, also number 7. Same matter.
What is required here?
Lordship, it is the discussion is still on, Lordship. On last I think
They have met 4 times, Your Lordship. Already now the point is that they have to check those calls.
I think if I understand correctly, though the matter has become infructuous in view of the company no longer being in existence. However, you say that the money, as far as disbursement to the employees is concerned, that is with you.
Yes, Your
That
Lordship.
is only to be verified.
Yes, Your Lordship. Now they
It
have
has to be deposited with you or with.
no, Lordship, the accumulated fund which they have skipped, which they have not paid for the employees under employees provident fund schemes. There are some balances are there which I have already in the writ petition, which I have already placed before this honorable court, that there are some funds which they can adjust it. So the meetings are on that the funds which they how they will adjust the fund. Now might be the thing is that some talks were there, some talks were there that the company is under liquidation also. So that is also there. So the talks is on way, and I think for that purpose only we need also some time, because if they are trying to settle the matter, then it's useless to prolong this case.
So we need, as per instruction, we need 6 weeks or 7 weeks, Your Lordship.
Why so long? Would it take that much time?
Yeah, they
Lordship,
have to contact
actually,
all those ex-staff who are no more while they are staying. They have to record.
Lordship, the staffs who are already retired, because the funds are also
Due and payable to them.
Yes.
due and payable to them. So I think so that is the
Yes.
reason.
We'll see. 4 weeks then. Mr. L.M. Sangma, Legal Counsel for the petitioner, has submitted that the process or determination of the exact amount to be paid to the employees, some of whom have since retired, is underway, and as such, sometime is prayed for the said process to be completed and a report to be filed before this court. Ms. P. Versace, Legal Counsel for the respondent EPF, has also expressed the same view and has agreed that some time is required for the process for the matter to be finalized and the complete picture to emerge, for which this court will be duly apprised of. Since the process would take some time, the parties have prayed for 6 weeks time for the same. 6 weeks.
Yes, Lordship.
On pre-made, the same as allowed. This is matter of just 6 weeks. So you will undertake to contact all those employees.
Yes.
find out how much is due to them,
Yes, Your Lordship.
and then you can also, do you have the authority to disburse, or who will do the disbursement?
No, Lordship, first they have to deposit the dues. Thereafter, through the unique link ID, the employees, the beneficiaries, they have to claim the amounts through their IDs. It directly goes to the bank account. So, and also some part is there as a pension amount. Around 8.35%, it is accumulated as a pension amount. So once they deposit, and after that the pension amount also will, the employees will start getting the pensions, which they are not getting now.
So we take it as the order was dictated, that the process is going on.
Yes.
And we'll see. So report
Yes,
is to
Your
be filed.
Lordship. Item number 7 also.
Item 1 and 7.
Item 1 and 7.
Katuka, 7.
Yeah, 7
Seven,
also similar
Similar
matter.
matter, because under notification is under challenged in 7.
Katuka, 7.
Matters.
So this is matter after 6 weeks. So 6 weeks then.
Highly obliged, Your Lordship.
Obliged.
Please, back to mention item number 2. Praying for 2 weeks time.
Lordship, no objections.
On permit by the petitioner, this is matter after 2 weeks.
May it please Your Lordship. Lordship, with the consent of both the parties, Your Lordship, I would like to make a joint prayer to make a mention of item number 10, 11 and 12, Your Lordship.
No objection, Lordship.
10, 11, 12.
10, 11 and 12, Your Lordship.
What about 13, 14?
13, 14, we'll make some little summation, some small prayer will make, my Lord, when the item is called.
Who's the appearing for the petitioner?
In item number 10, Your Lordship, I'm the petitioner, Your Lordship.
In 10,
Yes, Lordship. 11, 12, and my Lord, we.
11 and 12.
I'm the respondent, Your Lordship.
I'm appearing on behalf of the, my Lord, the arguing counsel, my Lord.
For
Yes, I am.
11 and 12.
Yes, Lordship.
On permit, I have to get 10 more. On permit by the petitioner, not objected to by respondent, matters adjourned. This system after 2 weeks. To 11, 12 on permit by the respondent. CBI.
Your Lordship, it's a joint request from both the parties.
Joint request, my Lord.
On permit with the parties. Okay. Then same order. On permit by the parties. This is matter after 2 weeks.
Lordship.
Much obliged, Lordship.
May it please Your Lordship. Lordship, I beg to make a mention of item number 15 on behalf of Mr. A.H. Karwanam. My Lord, kindly have the matter after 2 weeks, my Lord. I've seen the consent of the opposite party.
No objection, Lordship.
On permit by Mr. J.N. Leonard, seeking accommodation on the ground that the conducting counsel is indisposed and could not appear for the court today, the same not being objected to by the learned counsel for the petitioner, matters adjourned. This is same after 3 weeks.
Tabling branch.
Obliged, Lordship.
From supplementary cause list, item number 1.
Lordship, I'm praying that this matter may come up at the end of the board. Mr. Polly is on legs at the moment.
End of the board.
Obliged to move.
From daily list, item number 4.
Yes.
Your Lordship, I would pray if this matter may be taken up at the end of the board, Your Lordship. Lordship.
End of the board. Item number 5.
Yes. You appear for the petition?
My lord, this is a state appeal, my lord. Mr. Subhashis Sen is conducting this matter. His matter is going on, my lord, since quite long, in court number 4, my lord. So we can have this matter at the end of the board, my lord, if the other sides are ready, my lord.
We have 2-3 matters then. We'll have it some other day then.
My lord.
On Premier Vaji and Mr. Leonard G. appearing for the petitioner, state petitioner. Matters adjourned. List the same after 2 weeks.
Highly obliged, Lordship.
Item number 8.
Yes. Yes, Miss. What is it? It's the first appeal.
It's a first appeal, Your Lordship.
Previous matter may be passed over. Is coming, Lordship.
My Lord also has expressed that Your Lordship have to. After 2 weeks, Your Lordship. Yes, Mr. Asu has already told that he will take some time also to complete his arguments.
On Premier Vaji appellant, this is matter of 2 weeks.
Lordship.
Item number 13.
Yes, Mr. Panthi, what
My lord,
is
this matter, my lord, we are supposed to file some compilation, my lord, and it's quite thick, my lord, it's voluminous. My lord, we have not been able to done it, my lord, so probably we'll have to pray for some time, my lord.
Mr. S. Panthi, Land Counsel for the petitioner, has submitted that the petitioner desires to file compilation for reference at the hearing. However, the same could not be prepared to be filed today, and as such, accommodation is sought for in this regard. As prayed for, pray aloud. This is matter of 2 weeks.
Lordship.
So there will be 13 and 14.
Yes, Lordship.
Second call from supplementary causes. Item number 1.
Mr. Paul is still on legs.
See, Miss, I've just briefly gone through the petition. This is a prayer for transit bill.
My lord, here, my lord, this application has been filed under section 482 of the Bharatiya Nagarik Suraksha Sanhita. Is under the new act. Whereas, my lord, the FIR that was prior pertains to the old act. And therefore, in terms of the new act also, my lord, as per section 431, if my lord will see the new act, section 531 of the
Second clause.
Yes, right, my lord.
531.
Yes.
Yes.
It says, my lord, clause 2, notwithstanding such repeal, if immediately before the date on which this Sanchita comes into force, there is any appeal application, trial, inquiry or investigation pending, then such appeal applications, trial, inquiry or investigation shall be disposed of, continued, held or made as the case may be in accordance with the provisions of the Code of Criminal Procedure 1973. So in this regard, the applications which has been filed, my lord, this is not maintainable. It has to be dismissed, my lord.
Your Lordship, I'll take instructions on the matter. If the matter may come up on Monday.
You see, I think it's very apparent. Very apparent. The provision is very clear. The matter pertains to an event prior to 1st of July.
Your Lordship.
My lord.
Anything, after 1st of July, well. what you can do, you withdraw this petition, file a fresh one.
Well, it's
Oh, you withdraw it and file a fresh application.
well, it's this would the FIR, my lords, the predating of the FIR, in my humble submission, my lords, would not have an effect insofar as the application is concerned. Because what your lordships are dealing with is,
Because I believe now once the FIR has been filed,
my lords,
investigation would be launched and the proceedings started.
my lords,
So once it has started, then
that is for the purposes of that case, my lords. Insofar as the application before your lordships would be, my lords, it would be under BNSS.
No, my lord, that is wrong.
Your lordships cannot exercise powers under the CRPC anymore, my lords, post the promulgation of the new laws.
What about this 531?
I'll just take your lordships, section 531, my lords.
Yes.
My lords, the Code of Civil Procedure 1973 is hereby repealed. Notwithstanding such a commencement, hereinafter referred to as the code, if the Sanhita had not come into force, all notifications not relevant, my lords. BNC would not be relevant. A is relevant if immediately before the date on which the Sanhita comes into force. Inquiry investigation here in this case would continue under the IPC. That's correct, my lords, that we have said. Insofar as your lordships exercising the power, my lords, that would have to be under the BNSS.
My lord, that is wrong, my lord. If
See, Mr. Paul, if I am not mistaken, Mr. Shulai the other day was referring to an order passed by the Delhi High Court in this regard. Perhaps there may be some confusion. So
because what has happened is, my lords, from that date, your lordships are exercising powers under
that's true.
earlier, my lords, CRPC and now under the BNSS. This power would be exercised post the notification by the central government.
Yes, true.
So, therefore, my lords, your lordships would be exercising powers under 482 of the code of the Sanhita.
But we are talking about the proceeding which precedes the.
That investigation would go on under the IPC, my lords. That investigation is independent of any power. This is not continuation of those powers. These are independent proceedings. Your lordships are now exercising powers only under the BNSS. Insofar as the code is concerned, my lords, that stands repealed insofar as this court is concerned.
My lord, as far as old cases are concerned, where
We'll
it is.
please clarify on this matter. Try to get some authority.
Well, hardly any authorities. As a matter of fact, what falls from your lordships will now be an authority for the rest of the country.
Try to get that.
Delhi High Court, my lords.
I think I have not gone through it. I don't know what is the sum and substance of the.
Because 438, my lords, if I may understand, earlier 438, now 482, is an independent power exercised by your lordships. That has nothing to do with the case, my lords.
It is. It can be. It can be.
It is not a continuation of the trial.
My lord, the section 531 of the Act, it clearly says if any investigation also is pending. But if any investigation now, my lord, the petitioner herein, my lord, seeking bail as regard to the old case which was already pending, investigation is pending. Now, when they are moving this bail, they cannot move under this new act. They have to move under the old act, my lord. This is what section 531 says, my lord.
See, Mr. We have to look at a situation. See, where we are presently, taking up matters under the new act.
Presently, yes.
Under the new code.
Any case, my lord, which has been registered after coming of the notification, my lord, those will proceed under the new act. Under the new act.
I think what my learned friend is confusing is, my lords, there are two codes. One is the BNS, that is the Bharatiya Nyaya Sanghita. That is, my lords, the replacement for the IPC. What he's trying to say is, my lords, that the investigation would be under the IPC and not under the BNS. I concede to that.
No, my lord. What
are you trying to say? It will be under BNS. 531 says that it has to be under IPC. Now the question arises, my lords, is whether your lordships are exercising powers in that trial. 482 or 438 as it was then, my lords, is not part of a trial proceeding. It is an inherent power that is vested under the code before your lordships, my lords. So that power would not be in any way infringed insofar as that proceedings under that particular investigation is concerned. It is an independent power being exercised by your lordships. So once it is an independent power, my lords, we would have to see on the date of the registration of the application before your lordships, whether it would be under, whether the old code applies or the new code applies. Admittedly, it's the new code.
If, my lord, this be the situation, this will create a lot of confusion, my lord. Because if the cases are prior to the notification, my lord, those are registered under IPC. and my lord, subsequent bail application or whatever, my lord, in my understanding of the law and as per section 531, my lord, which I can understand, my lord, all those old proceedings which were pending prior to the notification, those will proceed under CRPC. My lord.
But we are looking here, you see, at an area.
Get me
We're looking at a, which is new.
Very, very new, my lord, yes.
We don't know, of course, the underlying principle, is well settled.
Because 3 judgments were
The only concern is, as Mr. Paul rightly said, see, we have to tread carefully so as to, not create a wrong precedent.
My lord.
Well, it's 3 judgments. Gurbakh Singh, that that other matter from Karnataka. I'm sorry, Malas, the name is a little difficult. There, the Honorable Supreme Court has categorically held, Malas, 438 is a independent power altogether. It has nothing to do with the trial of a certain case. At any stage, your lordships would have that inherent power under your lordships under 438, the new code, so that, Malas, that power can be exercised under certain circumstances.
We'll take it up on Monday.
Malas, may I pray for Tuesday, Malas? Monday, I have a little difficulty.
Tuesday again. Premier parties. This matter on Tuesday.
16th, Malas. Huh? I'm grateful.
Second call from daily list, item number 4.
This is a relatively old matter. May I pray for a little accommodation next week, if it is not inconvenient?
In fact, there are 2 identical cases were filed, my lord. The one case has already been resolved by the department. If my friend can have instruction in this matter.
I'll seek instruction.
Because after filing of the case, there was a scheme from the government, my lord.
This is a subsidy scheme.
Subsidy
scheme. But after filing of the case, there was a scheme that of settlement of the cases. So one other matter that was Green Valley.
Acha.
That has been settled. So if you make,
I'll seek instructions, Malas. Then we need not burden your lordship with this entire.
I'll give you 3 weeks time.
3 weeks.
Might have been settled.
We'll just file it.
On premier parties, this is matter after 3 weeks.
But as far as the other case that was with the procedural laws, my lord, the CRPC which has come now, because law is very well settled, my lord, the procedural laws are always retrospective, my lord. Maybe the offences have already been registered under the old IPC, but procedural law, the moment it is notified, it
has to be under the new.
So that
procedural law, I can also.
My lord friend can also.
Assist on that.
Because whatever falls from your lordships, my lords, I would pray that it would have a larger bearing, because pan India, then this judgment would be referred to, my lords. We'll assist your lordships, my lords, whatever.
It'll be, the court would need, clarification on this.
In fact, I'll place this as well. Because when 1973 CRPC came, my lord, this situation arisen that time.
Same situation arose.
Because IPC is very old, my lord.
If you can say precedents, that would be.
So it is not that those 3 laws were a set of laws, my lord. IPC is of 19th century, my lord. CRPC was
subsequently amended again.
So is it not that all 3 laws have to be taken together? So case registered under old IPC has to be tried under old CRPC. That is not a correct proposition.
Procedural law would be, my lords, from the date of the notification. And otherwise also your lordships are exercising powers independent of whatever is the proceeding. That has no bearing.
That is one aspect, but otherwise the larger aspect is that the new procedural code will come into effect, and henceforth whatever application have to file, those have to file under
the BNSS.
Under the new procedural code.
I would agree with that. But then even then.
Of course, the case will remain under IPC.
That is true.
That would be saved by 531A.
Because that is substantive law.
We'll try and assist your lordships. We'll try and give whatever judgments are available.
We try to find out how 531 is
1973, there must be many cases during that time, my lord, on the same issue when the CRPC
try
came.
to get some precedent then.
We'll try and assist your lordships.
Thank you.
Obliged.
531 का नया इंटरप्रिटेशन समझ में आया।
We'll apply retrospectively.